So here is the issue that everybody is talking about. And this is the tweet that had 4.8 million views. Everybody's messaging me about this. And this is where it started. Started with David Wald. Now, David Wald is a voice actor who worked at one point for Crunchyroll / Funimation. So he says, "Dear friends, if you sent me anything care of Funimation or Crunchyroll in the past 5 years, I apologize. I did not get it. I learned yesterday that Crunchyroll opened my private mail, and we're going to put a pin in this where I'm just going to read it, but private, we're going to underline that. Threw away your letters and passed out included items to their staff." Now, from what I understand, and also in the VTubing world, I understand there's other corporations that may be doing this. For example, I have heard a lot of allegations on this happening at Niji Sanji, right? With Niji creators not getting what their fan mail. I've heard this with other places as well. I've also dealt with a lot of corporations that when somebody quits or they gives notice to quit, they don't give them anything else. So if they were going to receive something and it came in, let's say it was a goodbye gift, right? They didn't get that gift. That is something I have heard commonly, and it's not just in the US. I've heard that in other countries as well. So this is something that is a little bit of an international issue. And let me just come right off and say it, because I'm going to explain to you guys the law in the United States. This is not the law necessarily in Japan. So Niji simps out there, the Fujos out there that are watching, listen, Niji's another day, right? We're going to talk about US law, what would apply to a Crunchyroll or Funimation or a corporation operating in America and with US mail. But regardless of whether or not this is illegal, and we're going to get into the legalities of it and really explain it, because a lot of people on the internet don't understand this at all. And fortunately, your boy may or may not have written some policies regarding this and may or may not know a thing or two about this, this specific topic. So this is fucked up morally. So regardless of what I'm going to say about the law, this is a morally fucked up thing to do, right? So let's start with that, right? It's wrong, right? Now, sometimes things that are wrong are not illegal, but is it morally wrong? Yes. Okay, so we'll start with that and just get that out of the way. It is morally wrong for a corporation, when somebody is sent mail, especially if it's marked as personal or marked as even confidential, right, to get that mail opened, right? That's morally wrong. Now, is it legally wrong? That's a big question mark. We're going to answer that. So here's the allegation, the first allegation, and then David Wald, the voice actor, goes on to give us some examples. So he goes on to give an example of something that he did not receive. Where is it? Right here. So he says right here, "Dear fellow workers at Crunchyroll, below is a photo of the complete contents of one of the packages addressed to me that was opened and distributed to employees. If you ended up in possession of any of it, I would very much like it returned to me." So this was something that was opened. It was addressed to him, and it was opened and I guess passed around like a cup of pink lemonade. And somebody else received these kind of spicy little yaoi photos over here. So clearly, there was the heist of this information, a heist of this this artwork, which quickly was taken to the bathroom, and the staff at Funimation and Crunchyroll proceeded to goon furiously to this material immediately upon it being misappropriated, right? But was it misappropriated? Let's get to the law, shall we? So everybody knows this is federal law. This is not state law. It's federal law. So therefore, it's at a different level. Now, there are state laws that can relate to mail, but typically it's within the province of the federal government. And specifically, it falls under 18 USC 1702. And 18-1702 is in the mail statute. It's, a lot of statutes related to the post, but the specific one is under 1872. 18 USC, US Code 1702, is obstruction of correspondence. So here's the language of obstruction of correspondence, okay? Whoever takes any letter, postal card, or package out of any postal office or any authorized depository for mail matter, or for any letter or mail carrier, or which has been in any post office or authorized depository, or in the custody of any letter or mail carrier before it has been delivered to the person to whom it was directed, with design to obstruct the correspondence, or to pry into the business or secrets of another, or opens, secretes, I love the word secrete, embezzles, or destroys the same, shall be fined under this title and imprisoned not more than 5 years or both. So you can be imprisoned multiple years for this specific violation. So when you look at this and you look at what happened to David Wald, I think most people off the top of their head would think that this was violated, because they would look at it and say, well, you know, this is a situation where, you know, there was a letter or postcard or package, right? So some of them were letters, some of them were packages, some of them were probably postcards too. And it was not given to him. And because it was not given to him, they're guilty of this crime. It's not that simple. Because the thing is that the law is not just exactly how it's written, it's how things are interpreted and how the judges have applied the case law and the interpretations of what the words mean. So courts have gone into these words and said, what do they mean? They don't mean what you think they mean. And there's two things. First of all, the main word here is actually not person, because person is, remember, corporations are people too, right? The main word here is actually delivered. Delivered. And when mail has been delivered. Okay? So this only applies to mail that is opened before it's been delivered. Once it's delivered, they have no responsibility for who opens it after it's delivered. So are you seeing where this is going? I think some of the smarter people in the chat are seeing where this is going. Once it's delivered, so it's opened, hands off. Here's how courts have defined this. Courts have looked at this and said, if it gets to the address where it's supposed to go, that's delivered. It's not the post office. Here's why. The post office cannot control people. When mail is delivered, the post office has no idea whether or not that person is actually there or not. The only thing they can do is say, oh, it was delivered to this address. They don't know whether the person whose name on it, and that person could be Santa Claus, that person could be, you know, the Grinch, whoever else, right? Because there's letters addressed to Santa Claus, the Grinch, whatever. Somebody opens that. Well, all that matters is where is it delivered? Was it delivered to that specific address? That's what they care about. And courts have refused to hold people liable for opening mail that's at that address to which it's been delivered. The person, right, is implied to be the business entity or whatever other thing, whatever it was delivered to as an address. So in a corporate context, this person was working as an employee of Crunchyroll and Funimation. So long as the address was Crunchyroll or Funimation, they're not going to hold them liable. And here's what's even more crazy. And I've looked into this. Even if the mail is marked personal, and sometimes even if it's marked confidential, they can open it as a business. Let me say that once again. Let's say you receive a letter to your business address and your boss decides to open a personal letter to you, but it was delivered to the business address. The courts are not really going to hold them liable. They're not going to hold them liable, even if it's marked personal. Now, confidential, I want to put a little asterisk, because if it's confidential, there are certain circumstances, like, for example, if it's attorney mail, right, where there might be other things at play, other regulations at play. But just if it's Joe Schmo, regular employee, and a voice actor is not a person in a position of confidence, not a doctor or a lawyer or somebody else, there's no medical privacy, stuff like that, they're not going to hold them liable. And here's the next thing. I guarantee you, why? Because I wrote these things, that there is a policy, one of those hundreds of pages of policies, which most people don't read, because just like that human centipede episode of South Park, it can't read, right? It's interesting because the policies will say that that they can open the mail, right? They can open the mail. And they're going to warn you, hey, if you get something sent to the job, we have permission to open it. That's for liability purposes. So they're going to cover their ass on that. So they're double covered. Number one, courts are going to interpret it that way. Number two, you signed off on it and you've approved it. And I guarantee you David Walt approved it. Now, does that make it good? No. But is that the law and the way it's enforced? Yes. It's unfortunate. And, that's part of my channel, guys. Sometimes people don't want to hear it. And certainly people want me to say they committed a felony, and Crunchyroll and Funimation need to all be locked up. And look, listen, I'm no fan of Crunchyroll and Funimation for separate reasons. But I'm going to be honest with you about the law and where there's a shot and where there's not a shot, right? So just being like, but this is what happens. And this is exactly why, if you have personal mail, do not get it sent to your company, period.